Hi, Philip Kirk in Nashville. This is going to be a short video about the legal term force majeure. This term has gotten some traction lately due to the lockdown of businesses here in the U.S. And for time context, and since I don't know exactly when this video will get published, we are currently entering the final phase of the first lockdown of businesses. The word force doesn't need to be defined, but the French word majeure simply means superior. In other words, this is a phrase concerning superior force. This term is found in countless high-level contracts, typically between businesses, and sets out the rules governing the parties' behavior and obligations in the event of an act which constitutes force majeure. Keep in mind that all unusual acts do not constitute force majeure, and whether or not a party may assert or rely on a force majeure provision in a contract is very much dependent upon the actual wording of the contract provision. In other words, there is no set wording for a force majeure clause, and it merely represents the agreement of the contracting parties. Now, while this provision is found in many business contracts, it rarely sees the light of day, and only in very rare and unusual circumstances does it ever become relevant. For instance, just because something happens to a business that causes it to have a loss of income or profit does not mean that the provision kicks in. I'm going to read you a copy of an actual force majeure clause found in a contract between two sophisticated parties, and I'll put it on the screen so you can read along with me. In the event compliance with any of the parties' obligations under this agreement is impractical or impossible due to any emergency, including but not limited to player strikes, management lockouts, labor disputes, embargoes, flood, earthquake, storm, lightning, fire, epidemic, acts of God, war, national emergency, civil disturbance or disobedience, riot, sabotage, terrorism, threats of sabotage or terrorism, restraint by court order or order of public authority, failure of machinery or equipment, or any other occurrence beyond the parties' reasonable control, each such occurrence being an event of force majeure, then the time for performance of such obligations shall be extended for a period equal to the duration of the event of force majeure. As you will notice, this provision is very comprehensive and pretty much covers any unusual activity that might befall a business. In light of current events, I have to assume that many business owners or managers have gotten out their lease agreements or other contracts and are reading them to see if they can take advantage of such a contract provision. Early on in the lockdown, you probably heard that the restaurant chain, the Cheesecake Factory, was not wanting to pay their rents that may be due. There was a lot of early speculation that this chain didn't have the funds to pay rent while the business was shuttered. I do not know whether or not that was in fact the case. My first guess would tend to be that Cheesecake Factory was probably required to give notice to their various landlords of their exercising the benefits of a possible force majeure clause, in their leases that is, and their giving notice was perhaps a requirement in some of their leases. I just don't know for sure. Also, the force majeure contract provision that I just read does contain a provision concerning acts of God. Some force majeure clauses may not provide that particular element, in that most force majeure clauses seem to be related to acts of men only, or perhaps governments, rather than acts of God. Acts of God are typically described as floods, hurricanes, tornadoes, lightning, and such. Keep in mind, though, that this video is not giving legal or financial advice. However, if a business believes it should take advantage of a force majeure clause in its contract, it should do so promptly and follow any notice provisions if such are required anywhere in the entire lease. You should make sure that the circumstances claimed are covered by the force majeure provision in the contract or lease. Generally speaking, if there is no provision for force majeure in a contract, it will not be automatically applied by a court. Now let's say that you own a restaurant that has been ordered by a state or local government authority to close due to a virus threat. And for this hypothetical example, we're going to assume the particular government entity has the constitutional authority to issue such an order. Under the force majeure clause I just read you, could the business benefit by the provision? I believe so, because the wording very specifically refers to restraint by court order or order of public authority. Now, this does not mean that the business can get out of their contract completely. It simply means that their obligations are to pick back up after the incident of force majeure is over. If this was a lease for, say, 5 years and the government order lasted for 2 months, then the lease would be extended for a period of 5 years and 2 months. Now for a fun question. Earlier I mentioned the term act of God. I want to ask you this question. If lightning strikes a church steeple, causing the church building to burn to the ground, is that an act of God? Let me know your answer below. Thanks very much for clicking on this video, and I sometimes forget to ask you to like it if you found anything redeeming in it. And please subscribe and hit the bell so that you'll get notice of my next video. So until then, over and out.